Good afternoon, guys. Welcome back. We will start in 5 minutes' time just to give a chance for the switch over from generators to ESCOM or vice versa. So we'll be back in 5 minutes' time. Thanks. See you then. Right, guys, we are back online again. Can we please turn to paragraph 6.3.2 on page 56 of the main bundle. Page 56, 6.3.2. We have the allocateur. Now, just to sum up, and this is a very important part of the presentation, is the allocateur. Now, the allocateur is the end portion of the bill of costs. You will have in your bill of costs, you have a preceding or your consultations and your pleadings and all the debits that you have, all your disbursements and whatever. So you'll have your preceding part of the bill of costs will then be the attendances, as I say, the pleadings, your consultations, your preparation, your discovery. All the items will be then costed out. You would have taken your well-kept file, you would have married it to the tariff, and you then have debited a charge. You've taken counsel's fees and sheriff's fees and expert witnesses' fees and any other disbursement that you had and would have notated them in normally chronological sequence. And then you come to a subtotal. Now those subtotals of fees and disbursements will then be taxed, checked, approved or disallowed by the taxing master, who is a clerk of the court or the registrar of the relevant court. Now, if you look at page 1 of your handout, give you a few moments to get there, page 1 of the handout, you'll see there that we have, in our example here, we have fees of 275,500 Rand. That will be the total of all the preceding fees that you have. And your disbursements that we have here in the example, 138,750. Now, in this instance here, we have said that the taxi master disallowed fees of 35,500 Rand and disallowed disbursements of 18,750 Rand. Now, why would the taxi master have disallowed certain amounts? Well, he or she will have determined that either the work was not done or that the tariff that you used was not applicable. For example, you might have included attorney and client debits on a party and party bill. So for whatever reason that the taxi master in his or her discretion has deemed, he or she has taxed off certain amounts. So in this case, we then have in our fees in our example here, from 275,500, he or she has taxed off 35,500, giving the net fees of 240,000 Rand. Now, please ignore those half marks in brackets. That's how we award marks for the attorney's admission exam. So please ignore that for present purposes. On the disbursement side, we deduct the 18,750 from the 138,750. We get net disbursements of 120,000 Rand. Now, guys, what follows is what we call the allocateur. How do you calculate the allocateur? So just to repeat, you have presented a bill of costs to the taxing master, and he or she has now taxed off those various amounts, and now we have to complete the allocateur. We're doing this, we'll do this a few times. Some of you people do this every day. Some of you have never done it, so please, those of you who know how to do it, please bear with me. But I know that from experience, a large percentage of our audience haven't done this before, so we'll have to help them, please. So please bear with me. Now, this is the only sequence you can follow. I repeat it, no shortcuts. This is the only procedure and sequence that you can use, nothing else. The moment you take shortcuts, you come a cropper. This is the only sequence that you can use. Now I'll explain on the left-hand side the capital DDAV. I'll explain as we go along. Now, the first D is the drawing fee. The drawing fee is 11% on fees only. Why 11%? That's what the statute says, 11%. And it's only on fees. Fees only, not at this stage on disbursements, only on fees. So please believe me when I say to you that 11% on my fees only, my fees are that 240,000 Rand. 11% on that is 26,400 Rand. I now have a subtotal. I total the 240,000 to the 26,400. I get 266,400. My second D, I now add my disbursements. Only now, not earlier, not later. I add my disbursements now. What were my net disbursements? They were 120,000 Rand. I add that to the 266,400. I now get 386,400. So my first D is the drawing fee, 11% on fees only. My second D, I bring down my disbursements. Now I get my A, my attendance fee. Now that's where most people have a battle with this sequence. The attendance fee is a staggered fee. On the first 10,000 Rand of that 386,400, on that first 10,000 Rand, it's 11%, which is then 1,100 Rand. If you follow me on those steps, those oblong rectangular things on the right-hand side, the step 1, step 2, all the way to step 5, you will follow what I'm saying. So on the first 10,000 Rand, it's 11%, 1,100 Rand. On the second segment of 10,000 Rand, it's 6%. 6% of 10,000 Rand is 600 Rand. The third segment is then 3% on the balance. Now, what's the balance? I had 386,000 up top there. I've taken away 2 segments of 10,000 Rand each. One was 11%, one was 6%. So I'm left with, if I take 386,400, I'm now left with 366,400. And the balance on that then, on 366,400, is then 10,992. I now have a subtotal. I add on that 1,100, 600, and the 10,992. I get 12,692 Rand. That's my attendance fee. I'll just stop there for a moment, guys. If you think that this, which is a fairly small bill, these amounts, does it pay to draft and tax your own bill of costs? Well, in this case, your drawing fee would have been 26,000 odd Rand, and your attendance is roughly 12,000 Rand. So 38,000 Rand for taxing this bill is not a bad reward. Right, I'll continue. So I now add that 12,692 Rand to my 386,400. I get 399,092 Rand. But I must now add my VAT, with my VAT registered. So VAT of my fees, now follow the arrow up. VAT on the fees, my fees were 240,000 Rand. So VAT on that is 36,000 Rand. My drawing fee, follow the arrow up. My drawing fee was 26,400 Rand. That's then 3,960 Rand. VAT on my attendance fee, the attendance fee was at 12,692. So it's 1,903 Rand and 80 cents. I then total all that, those three to that 399,092, I get 440,955.80. Easy peasy. Or don't you agree? Right, guys, let's go through it again. We'll do this a number of occasions and give you examples, and until hopefully you'll get the gist of it. I repeat, this is the allocateur. This is the end of your bill of costs. Your preceding pages will then contain all your preceding items on your bill of costs, all the fees, all the disbursements. And then you'll have your subtotal of 275,500, fees and disbursements 138,750. So less taxed off by taxi master, fees 35,500 and disbursements 18,750. So my net fees are 240,000 and disbursements net 120,000. I now get to my first D of the formula DDAV. My first D is the drawing fee, 11% on fees only. 11% therefore on the 240,000, I get 26,400. I now add that 26,400 to the 240,000, I get 266,400. My second D, I bring down my disbursements now. I bring down the 120,000 Rand and add that to the 266,400. I get 386,400. Now the third element, the DDA, the attendance, on the first 10,000 Rand, 11%, that's 1,100. The second 10,000, 6%, 600 Rand. So of the 386,400, I've taken away two lots of 10,000 Rand each. So I take away off 20,000 Rand of the 386, so I can now get 366,400. On that is 3%, 10,992. The total of my attendances are then 12,692. I then add that to the 386,400. I get 399,092. I'll then add my VAT on my fees, VAT on my drawing fees, VAT on attendance fees, and I total all that up, 440,955. Now, guys, I then give you an exercise which I want you to do on your own, please. We'll give you about 8 or 9 minutes to do it, and then we will give you the answer and go through the answer with you, and that we'll repeat a number of occasions. So we'll give you the exercise now, just a moment. Right, there you have the example. So my subtotal fees are 385,000 and disbursements are 238,750. A taxi master has taxed off fees of 45,000 Rand and disbursements of 28,750. You are VAT registered. Please complete the a la carte tour. So guys, please, using that format I gave you a few moments ago, please complete the a la carte tour. We'll give you 8 or 9 minutes. Thank you. Right, guys, let's go through this. The answer to this is 665,540.30. 665,540.30. But let's see how we got that. The drawing fee, or rather, first of all, the net fees are 340,000 Rand. The net disbursements are 210,000 Rand. Your drawing fee, 11% of 340,000 is 37,400. Remember, it's on fees only. I have a new subtotal. I add the 340,000 to the 37,400. I get 377,400. My second D, my drawing fee, sorry, my disbursements are 210,000. My new total is then 587,400. My attendance fee, the 11% on the first 10,000 is 1,100 Rand. The second 10,000 Rand is 6%, that's 600 Rand. And then 3% on the balance. The balance would then be 587,400 less the 20,000 Rand, the two segments. So that then 567,400 is then 17,022. So the total of those attendances are 18,722. I add that to the 587,400, I get 606,122. I have my VAT on fees, VAT on drawing fee, VAT on attendance fee, total of 665,540. I'll give you 2 minutes just to go through that. Those of you who went wrong, just see where you went wrong, please. Give you 2 minutes for that. All right, guys. So if you went wrong there, just see where you went wrong. Just a remark. What happens if your totals are less than the 20,000 Rand? Well, let's say the total of fees and disbursements are only 9,000 Rand. Then it'll be 11% on that amount less than 10,000 Rand. Let's say 17,000 Rand. It'll then be 11% on the first 10,000 and then 6% of the 7,000 Rand. So you do it then only up to those segments. If there's no balance, there's no balance. So on the first 10,000 Rand or portion thereof, it's 11%. If it's over 10,000 but less than 20,000 Rand, it's 6% on that balance of the portion. And then there's no other balance for the 3%. Right, let's do another exercise. There you have it. Please complete the a la carte tour. Give you a further 8 minutes. Right, guys, we're back on again, and I'll let you read this for 2 minutes, see where you went wrong, and I'll explain it again to you. Right, guys, let's just go through this again. And from the questions we're receiving, I gather that people are still having problems with, especially the A section, the DDA, the attendance. If I have 10 apples and I take away 1 apple, I have 9 left. If I take away a further apple, I have 8 apples left. Now it's the same with the A. I take away 1 segment of 10,000 Rand off that 1,086,297. I take away 1 apple from that, 10,000 Rand apple. That leaves me with whatever there, 1076. And I take away a further apple of 10,000 Rand. That leaves me with 1066. Look at steps 2 and 3 on the right-hand side. Then the question arises is, what happens if it's the total account is then only, let's say, 9,000 Rand? Well, then it's 11,000 Rand on 9,000 Rand, and there's no 6%, no 3%. If the account is, for example, 17,000 Rand, well, then it'll be 11% on the first 10,000, 6% on what is left, i.e. the 7,000 Rand. And then there's no 3%, because there's no balance over 20,000 Rand. So that's how you demarcate it. Hopefully that's, you can gather that. Now, guys, before we do a further exercise, I want you to go to page 69. We'll come back to these exercises now, but go back to page 69, please. And I want you to read paragraph 9.6 with me. Paragraph 9.6. Now, before I read this, just to explain this, besides the fees that you have got, when you tax a bill of costs, you're entitled to 2 further fees, your drawing fee and your attendance fee. In other words, besides all your trial matters and your motion matters and so on, you get a further reward, a further fee for drafting your bill, because it's taken you X hours to draft the bill. And then you are entitled to a reward for attendance and the taxation. So you get a drawing fee and an attendance fee. That's that 11% and 11, 6 and 3%. You're entitled to those 2 fees. Now, if we read paragraph 9.6, the penalties. Rule 70, section E, item 3B2 of the High Court rules determines the taxing master may, so I say may, he has a discretion, may, if he or she is satisfied that fees are being charged in the party and party bill of costs for work not done, for work for which fees are to be charged on attorney and client bill of costs, or which are excessively high, deny the attorney the remuneration referred to in items 1 and 2 of the section, drawing fee, and add on there, and attendance fee. So it's a drawing fee and attendance fee. If more than 20% of the number of items, and it should be including costs, including expenses, please change that. So it includes disbursements, or the total amount of the bill, including expenses, is taxed off. Now, what that means in plain English is that if the taxing master in the High Court taxes off more than 20%, 1/5 of your fees and disbursements together, he may deny you the drawing fee and the attendance fee. We go down, Magistrates Court Rule 3318 determines that where more than 1/4, now bear in mind in the High Court is 20%, now it's 1/4, 25% of the bill, and now it excludes expenses. In the High Court it includes expenses, in the Magistrates Court only excludes expenses. It's taxed off. The party shall not be allowed any cost of taxation. Shall, peremptory, the taxing master has no discretion. So in the High Court, he or she has a discretion. In the Magistrates Court, not a discretion. So to sum up, in the High Court, if the taxing master taxes off more than 20% of fees and disbursements, you may lose your drawing and attendance fee. In the Magistrates Court, 25%, excluding expenses, you shall lose it. Right, bear that in mind. I repeat, bear that in mind. Make sure that when you tax the bill of costs and there be things taxed off, calculate whether they've exceeded the 20% or 25%, as the case might be. Right. Give you a further example. I'll do this one and a further one for those of you who are battling. Here you have this. In this case, you are not VAT registered. You are not VAT registered. And I'll give you 2 minutes. And because I'm so kind and gentle and lovable, you should think why I'm only giving you 2 minutes. Give you 2 minutes. Carry on. Complete the à la carte 2. You are not VAT registered. Right, guys, here's the answer. 139,100. Why is that? You're not VAT registered, and lo and behold, more than 25% of fees and disbursements were taxed off. If you add the 140 and the 48,000, and you look at the tax off 36,000 and 1,205, more than 20% was taxed off. So therefore, you have no attendance fee, you have no drawing fee, you're not VAT registered. So there's your simple calculation. Now, when I give this lecture to the law students, I always bet them that I will catch them, and they deny that I'll catch them. And they give me a full box of sweets because I caught them out. I hope I didn't catch anybody out. You all got the point, hopefully. Right, guys, our last bill of costs à la carte. And I promise you this time there is no catch. You are VAT registered. Please complete this. And I have a question. Can you deviate from this DDAV? Guys, no, no, please do not deviate from this. Please do it only in this sequence, in this order, please. That's the only way you can do it. Any other way, the moment you take shortcuts, you come a cropper. Please only do it this way. I'll give you about 8 minutes. There is the answer to memo 4. Please go through it to see where you went wrong, if you went wrong. Give you 2 minutes for that. All right, guys, there you have it. If you went wrong, just see where you went wrong. I have a question from one of our guests that I'm to please explain the one where I caught some of you. Sorry about that. The no VAT and no drawing fees and so on. Just to remind you, paragraph 9.6, I said to you that in the High Court, if the taxing master taxes off more than 20% of fees and disbursements, you may lose your drawing fee and your attendance fee. In the match court, it's 25%, and you then shall lose it. But coming to the High Court, if you lose more than 20% taxed off of your fees and disbursements, you can lose your attendance and your drawing. Now, if you look at that 140,000 Rand fees, what was and the total of disbursement was 48,000. So your total of fees and disbursements were 148,000 Rand. Now 20% of that would have been 37,600. But what was taxed off was the 36,400 and the 12,500, giving you 48,900. So what was taxed off was far more than 20%. So therefore, you could have lost, in this case, you did lose the drawing fee and the attendance fee. So what you do is that in the case, always check what in the High Court, what was the total of your gross fees and gross disbursements, what was taxed off of fees and disbursements. If the total taxed off is more than 20% of the original fees and disbursements, you could lose your attendance and your drafting fees. And then in this case, there was no VAT, so it's a very simple calculation. Right, if we can go to item 10 on the handouts. So guys, we're now done with the litigious accounts, the bill of costs. We're now doing the non-litigious accounts. Now that's very simple. There's nothing strange there. Remember, you're required to give details to a client. You can't just say these days, unless there's an agreement, you can't just say lump sum Rand X. You have to itemize it. So here we have consulting with the client, taking instructions 2 hours, 2,000 Rand per hour, or pro rata thereof. That's 4,000 Rand. Consulting witness 3 hours, 6,000 Rand. Drawing statements, 10 pages at 200 Rand per page, so 2,000 Rand. Perusing police docket 4 hours, 8,000. Preparing for hearing, 3 hours is 6,000. Attend trial, 12,000. Travel time, 1,000. Now, travel time is a fee. Travel cost or disbursements, whether it's a taxi or petrol or Gautrain, is a disbursement. But travel time is a fee. So please distinguish that correctly. You have your subtotal fees of 39,000 Rand. You now add your VAT. Because guys, you normally do not charge VAT on disbursements. Most disbursements already have VAT, so you do not charge VAT on disbursements. Therefore, you have to first calculate all your fees and then do your VAT. Your total is in 44,000. Then you get your travel disbursements. In this case, there was a trip, 50 Rand, and then subtotal, and then less deposit paid and balance outstanding. And then up top there, you have the name of the firm, your name of the client, your tax invoice number, and then your date. So that's the story there. Nothing strange there. Any question, let me have it, but nothing strange there. Guys, we will break for 5 minutes. We'll come back around about 8:108, and we'll take it from there. Thank you. Be off in 5 minutes. Guys, apparently exercises 4 and 5 didn't show the bottom part, so we'll show it now for you. Here's exercise 4. We'll give you 2 minutes just to verify that. And then we'll show you the memo for exercise 5. Right, guys, then we move on. We have now done the a la carte tour for the litigious accounts and then the account for non-litigious matters. Can we then please go to paragraph 6.6 of your main handout, page 57. And while you go in there, just a reminder, you're more than welcome to let's have your questions. We'll do the presentation until 2 o'clock, and then from 2 o'clock onwards, we will answer your questions. Also, the carryovers from yesterday, we had a few questions from yesterday that we carried over. We'll answer them as well. And we start at paragraph 6.6. But the delay in drawing bills of costs. Guys, first of all, you shouldn't delay. The sooner you do your bills of costs, the sooner you get paid. Question: if you wait more than 3 years, does your bill of costs become prescribed? The answer is no. There used to be a school of thought that it prescribed after 3 years, but the present school of thought, which I agree with, is that because it is part of a court order, and a court order does not prescribe after 3 years, but normally only after 30 years, subject to certain things, that the delay in drawing a bill of costs does not give rise to a prescription on the bill of costs as such. Paragraph 6.7 and 6.8 we can do together. There are advantages and disadvantages in drawing your own bills of costs. The positive is the following, is that you can earn a fair amount of money. As you saw just now, your drawing fee or your attendance fee can be substantial. The higher the fees are and disbursements are, the higher your fees are. So there are certainly advantages. The disadvantage is that you need to become a specialist. You need to do it often, to get experience, and you need to do it as quickly as possible and as best as possible. And a busy attorney doesn't always have the space to maneuver to obtain all the information and become an expert. But if you can, then certainly do it yourselves. Cost consultants. You need not be an attorney to be a cost consultant. Point 1. Point 2, there's no qualification that you can per se obtain to become qualified as a cost consultant. A cost consultant who's not an attorney can become an expert in the field and can hold himself or herself out as a cost consultant, even though he or she is not admitted as an attorney. However, those persons cannot attend court, as we will see in a few moments' time. So how do attorneys and cost consultants arrange their fees? Let's take an example where a cost consultant is not an attorney And the cost consultant then draws the bill on behalf of the attorney. The consultant's fees are then determined by agreement between the attorney and the cost consultant. Normally, the consultant will take the drawing fee and a portion of the attendance fee. I'll tell you now just now why I say a portion. So it is negotiable between the attorney and the consultant. Normally, the attorney would then give the consultant the drawing fee and share in some percentage the attendance fee. Now, talking about the attendance fee, who can attend a taxation in the High Court? There has been and there is at the moment some dispute as to who may attend court. I know that in certain provinces, the Free State, they have their own rules. In Gauteng, we have our rules. Now, I want to read to you the directive of the Deputy Judge President, Judge Roland Sutherland, of 14 June last month, 22, as to who may attend taxation in the High Court. It reads as follows: until such time as a court decides otherwise, is directed any attorney permitted to practice may appear before the taxing master. Right of appearance is not required. I repeat, any attorney permitted to practice may appear before the taxing master. Right of appearance not required. Now, in other provinces, the courts require, or the taxing master requires, a right of appearance for the attorney who appears on taxation. So, guys, please ascertain from your provincial people what the rule is. I think in the Free State they require the appearance to a right of appearance to appear. In Gauteng, not. Now, Gauteng, as per the directive of 14 June, anybody who can appear for taxation and does not necessarily have a right of appearance as such. And cost consultants who are not attorneys permitted to practice may appear before the taxing master in order to assist with the presentation of the bills in the presence of an attorney permitted to practice or an advocate. The cost consultant may address the taxing master, whilst the attorney or advocate will take the responsibility for the presentation of the bill of costs. So they can present themselves, basically, the consultants, as expert witnesses. The directive further states, should the attorney or advocate appearing at the taxation not be from the firm of attorneys of record, or the advocate briefed in the hearing, the taxing master shall refuse to tax the bill in the absence of a signed certificate by an attorney from the firm whose bill is being presented. So, guys, the directive of Judge Sutherland, 14 June, clarifies the matter insofar as Gauteng is concerned. Outside Gauteng, please ascertain from your provincial bodies what the position is. So that's the situation at the moment in Gauteng. Going back to paragraph 6.9, just read that, nothing strange there. Paragraph 7. Settling of bills of costs, that's the payment. Settling in this case means payment of. Just make a note of that, nothing's changed. We then go to paragraph 8.2. Is the certificate that the taxing master requires in the High Court, and then 8.2.3 in the Match Court. In the High Court, the taxing master will require a certificate where the attorney employs a consultant to draft the bill. The attorney must accept authorship of the bill in that wording, as you find in 8.2.1. In the Match Court, it's not required. That's paragraph 8.2.3. That's not required. Just a few words about chapter 5. Sorry, chapter 9. Sorry, 8.3. You may consent to taxation of the bill in your absence. That you only do if you are satisfied that the bill is in order What you should do, if you are satisfied, is then to talk to your colleague to try and arrange a settlement figure. He or she will then still be entitled to the drawing fee, but you might save on the attendance fee, but the attendance will then merely be a consent amount. Paragraph 9, 9.1. With a view to affording the party who has been awarded an order of costs to full indemnity for all costs reasonably incurred. Now, I want to talk about that word reasonably. We often find that in bills of costs, you will have the following item, especially in RAF cases. You will have the following item: to take a client to a doctor, wait for 3 hours, and travel back, it's a total of 5 hours. The taxi master will probably tax that off or diminish it, because the criteria is, was it reasonably incurred? Was it reasonably incurred? Remember, the basic rule is that they try and save costs as far as possible. So don't do things on the most expensive way, but the cheapest possible reasonable way. So if you take a client to a doctor, unless you're going to consult with a doctor, that's the proviso. Unless you're going to consult with a doctor, it's not reasonable for you to spend your time as a professional at a professional tariff to go and fetch your client, take him or her to the doctor, wait in the waiting room for 3 hours while the doctor's doing his or her work, and take the client back. That could be done by an unprofessional, anybody else, who doesn't charge the same fee tariff as you do. So the norm is always, is it reasonable? And we find that in taxi cases, tax cases, or the taxing cases, you'll get that taxed off. The same is said in 912. The clerk of the court shall on taxation disallow any charge unnecessarily incurred. Guys, no matter whatever, anything that's unnecessarily incurred will find the sanction of being taxed off. You can read 921, 922, you can go through. 9.5, practical hints. Go through that, that's very important. We need to go through it now. But 9.5 gives you a very handy checklist. And I want to give you a further checklist now that's not in your manual, but I want to give it to you, which is a very handy checklist that we find in Subia's book, S-U-B-B-I-A-H, Subia's book on taxation, on page 48. I'll give it to you now, with recognition to Francis Subia. The following could be a checklist when you tax and draft your bill. 1, is the bill drafted on the correct scale, i.e. party and party, attorney and client? Is the bill drafted on the correct tariff or scale? 2, if it is a party and party bill, filter out any attorney and client costs. If it's a party and party bill, filter out any attorney and client items. 3, are there any above tariff items? Are there any above tariff items? If so, negotiate. If so, motivate. If so, motivate. 4, are time-based items correct? Are time-based items correct? It'll be silly if counsel's account says attend attorney and client for 3 hours and you say 4 hours. Number 5, are folios or pages correct? Are folios or pages correct? 6, are there any duplicate items? Next, can you motivate counsel's fees? In other words, are they so high that you have to motivate it? Next, can you vouch for all disbursements? I.e., do you have proper vouchers to substantiate all disbursements? Next, have you charged for aborted settlement negotiations? Have you addressed and attended to aborted or unsuccessful settlement consultations? Were any costs reserved? Were any costs reserved? If so, first they have those costs adjudicated upon by the court. Next, were there any special cost orders? Were there any special cost orders, such as qualifying fees for expert witnesses? And is the bill dated and numbered? Then 9.8, interest on a taxed allocateur. The moment the bill of costs is taxed, it becomes a liquid document and it carries interest at the ordinary rate of interest in terms of the Prescribed Rate of Interest Act. The moment it's taxed. Paragraph 9.9 is just the consent to taxation. Paragraph 10, chapter 10 rather, review of taxation. Now, if we look at paragraph 10.3, the principles upon which a court will interfere will then be the taxing master acted upon a wrong principle, did not exercise his or her discretion properly or at all, disregarded factors or principles which he should have taken into account, incorrectly interpreted rules of law, and clearly misdirected himself or herself, decision being incorrect. Now, guys, a review is done in terms of Rule 35 sub 1 of the Match Court and the High Court Rule 48. Those give you the procedures. So if your client is unsatisfied with the taxation of a bill of costs in the Match Court or High Court, you can use these rules to take it on review through a court. Chapter 11, the recovery of costs. Now, remember, please, that costs belong to the client. Now, if costs are taxed after judgment, awarding the costs, you issue a writ immediately. If costs are taxed after judgment, awarding the costs, you can issue a writ immediately. If costs are taxed or settled by agreement, if costs are taxed or settled by agreement, then you have to first issue a summons. You cannot issue a writ. Prior to taxation, the attorney's costs are unliquidated and must first be taxed. Paragraph chapter 12 rather, legal aid matters. We have dealt with that partially. You are bound by the tariff. You cannot accept or negotiate a fee from the client over and above the amount that legal aid will pay you. Any cost order obtained by the client is deemed to be ceded to the legal aid board. And as I said, in regard to pro bono matters, there's no such automatic cession. You are obliged to then negotiate with your client that in the event of success, it'll be ceded to you. But that's then per contract. A word about two things that are not in your manual. Pre-litigation costs. Pre-litigation costs. Now, normally, a taxi master will not allow you any pre-litigation costs. This is the so-called Brits versus Engelbrecht rule. Now, Brits versus Engelbrecht was 1907 Transvaal case, 1907, which then gave certain guidelines. That guideline was, as a rule, party-in-party costs would commence only with the issue of a summons or the motion. That was called the rule in the Brits and others versus Engelbrecht. Now, over the years, this has been watered down. And now there's a new test. And the test now is the following. And that's in the case of CITWA, C-I-T-W-A, which you'll find in your list of authorities, which you'll be getting in the next few days. The test now for deciding whether to allow pre-litigation costs is whether those costs were reasonably and necessarily incurred to secure the litigant's position. That's CITWA. I repeat, the test now for deciding whether to allow pre-litigation costs is whether those costs were reasonably and necessarily incurred to secure the litigant's position. Now, I think that especially in RAF cases, you have to do a fair amount of work before the litigation commences. And you can use the CITWA case to persuade the taxi master to allow you pre-litigation costs. CITWA's case would be authority, and it's been followed normally by taxi masters to allow you pre-litigation costs. You'll recall that in terms of the recommendations from the SA Law Commission, they're looking at a formula as well to allow pre-litigation costs. A further matter I want to discuss with you before we go on to certain general things is security for costs, which is not in your manual, security for costs. This is in terms of Rule 47 of the High Court, Rule 47 High Court, and Rule 62 of the Match Court. What are we talking about here? Let's say that your client is a defendant and your client is sued by a plaintiff who, A, is not domiciled or resident in the country, or is an insolvent, or vexatious litigant, person of straw, or a legal persona. Let's call them a foreigner, insolvent, vexatious litigant, person of straw, or certain legal persona. If they sue your client and you readily believe, and you have grounds to prove your belief, that if there was the adverse cost order against that person, they wouldn't be able to pay the costs of the litigation, or any adverse cost order. If the plaintiff falls under one of those categories, you can bring an application in terms of Rule 47 High Court or Match Court Rule 62 to require them to provide security for costs. In other words, that they have to put up some security to say to the court, well, even in the case of an adverse cost order, I can pay those costs. Now, it's normally done by way of a surety bond or a payment into the clerk of the court, the registrar of the court. And how do you determine the quantum? Now, there's no rule about this except a rule of practice. The rule of practice is that you will draw a pro forma, in other words, just an informal bill, as at the end of day one. In other words, you hypothetically envisage what the costs would be to the end of day one. And you ask the taxi master just to not tax it, but just to say that that would be within the realm of probability that that quantum would be more or less what it would cost for the end of day one. And that you then ask the court to order that the plaintiff provides those costs by way of security. Right, guys, that does that in that portion of the lecture presentation. And I now give you the general items. Now, this is derived from my experience, my research. Unfortunately, is not on writing and cannot be reduced to writing. It's merely my experience. So please jot this down. All the court cases I refer to will be included in the list of authorities which we're getting. But just please jot down the various principles which I'll be giving you. These are practical things. And then we'll be talking about counsel's fees as well as we go along now. First general item, it is usual practice for attorneys to make their charges time-related. However, the taxi master in the court has a discretion to deviate from a rule so not to benefit slow or inefficient work. Point I make, that's the case of Henny de Beer Game Lodge. Henny de Beer Game Lodge. So a court will not award slow or inefficient work. We're taxed off. Secondly, the case of Levine and Society of Advocates. It's unfair to burden a party liable for fees for work done twice, i.e. by attorney and correspondent or attorney and advocate. You will not be able to charge twice. Next, also Levine case. Can counsel charge for consulting with a witness? Normally, no. Counsel will not be allowed to charge for consulting with a witness unless where the witness is a necessary witness in a complex and serious matter. As a general rule, charges by an attorney for consultation with a counsel after a brief on application are not allowed. The general rule, charges by an attorney for consultations with a counsel after brief on application, not allowed. Levine's case. The next two, also Levine. Advice on evidence is an attorney and client cost and not a party and party cost. Advice on evidence is an attorney and client cost and not a party and party cost. Heads of argument are deemed to be part of preparation for argument and cannot be charged separately on a party and party basis. Heads of argument cannot be charged separately on a party and party basis. And then the last part of Levine, counsel may not charge for inspection of attorney's file, not on party and party or in other scale. Counsel may not charge for inspection on attorney's file, not on party and party or any other scale. Then from the case of Solidarity versus SABC, 2016, de bonus proprius. And you recall that we said that de bonus proprius was where the attorney was punished, sanctioned because of some untoward behavior. But in the case of SABC, this was extended not only against the attorney, but also against the official to punish him or her for intentional, obstructive or illegal behavior. So even going beyond the conduct of the attorney, where the official of somebody has been intentionally obstructive or illegal behavior, then the court can order costs against him or her. The next is the matter of BioWatch. BioWatch, that's a well-known case. In constitutional matters, costs should not be awarded against an unsuccessful private litigant who seeks to vindicate constitutional rights against the state. That's the so-called BioWatch principle. In constitutional matters, costs should not be awarded against unsuccessful private litigants who seek to vindicate constitutional rights. Unless, and that's the exception, unless the litigation was frivolous, vexatious, improperly motivated, or in the interest of justice. The whole idea is that where John Citizen fights against the state, John Citizen should not be lumped with costs if he or she loses, unless the exceptions apply. Then the case of Lushdon, L-U-S-H, Lushdon versus MEC. Again, cost debate appropriates awarded against state attorney and public officials for damages arising from the birth of a child, defense of claim unjustified and reckless, conduct of the state official showing such a degree of incompetence and indifference as to be held personally liable for a portion of the costs. Funding of litigation by non-litigating parties. What this rule applies to is the following. You have a situation where you have two large corporations in an argument, but they litigate through two empty shell companies, almost way off shelf companies. In other words, A is a dormant or semi-dormant company and B is the same, having no assets, but behind them are two large corporations, but they use these front organizations so that if there's a cost order against them, that the cost order will not be satisfied because the companies themselves, who are the actual litigants, have no assets. And in the case of EP property projects, the Registrar of Deeds in Cape Town, the court said that we reserve the right to go beyond the curtains put up by these large corporations and awarding attorney and client costs against non-litigating founders if the funder had a direct and substantial interest in the litigation, and that these corporations or the funders were the real litigants in the sense of being in full control of litigation. So in a case like that, EP property projects, the court, the taxing officer will go behind the people in front of them. Settlement negotiations in litigious matters are party and party costs. Settlement negotiations in litigious matters are party and party costs. That's Rule 70, Item A6. Settlement negotiations in litigious matters are party and party costs. Rule 70, Item A6. Since consultations on settlement between attorney and his or her client forms part of settlement negotiations, the fees for such consultations are party and party. So consultations with your client as part of settlement negotiations are party and party costs. Now, we spoke just now about pre-litigation costs, and by way of a further motivation to substantiate your argument to the taxi master, we talk about the case of Van Rooyen versus Commercial Union, where pre-litigation costs, RF, were allowed on party and party, Van Rooyen's case. In the match court, there's no provision in the rules for pre-litigation costs. In match court, there's no provision at all for pre-litigation costs. However, I refer you to Francis Subia's book, page 133, which gives a very persuasive argument which you can use to persuade your taxi master to allow pre-litigation costs in the match court. Francis Subia's book at page 133. What about the costs of amicus curiae, the so-called friends of the court? This you will get, for example, in, let's say, in gender cases where some NGO applies for leave to become part of the court case. Normally, they're not awarded their costs. In the match court, counsel's fees only allowed on taxation if the court made such an order in terms of Rule 33.8, because of the complexity of the matter and so on. So in match court, Rule 33.8 determines counsel's fees. Next point. A case of RAF versus LaRue. An attorney with right of appearance in the High Court, carrying out the functions of an advocate, will be remunerated as if he or she was in a counsel. So in the RF case, it was held that an attorney doing an advocate's work will be remunerated on the same basis for an order for work done actually done. Subia, page 28. So RAF versus LaRue and Subia 28. If attorney appears in the High Court doing the counsel's work, he or she will be paid accordingly. Next point, attorney acting for himself or herself can recover fees except instructions and consultations. An attorney acting for himself or herself can recover fees except instructions and consultation. Subia's book, page 36. Let's talk about waiting time. What is the rule there? Well, I refer you to the case of General Leasing Corporation versus Lowe, General Leasing Corporation and Lowe. No provision is made in the tariff for waiting time when the matter is crowded out of that day's court roll. No provision is made in the tariff for waiting time when the matter is crowded out for that day's court roll. But some taxi masters consider this cost on a common law basis of wasted costs, and that was held in the general leasing matter. So if your matter is crowded out on that day, you can use general leasing case to persuade the taxi master to allow it. That's on party point. On attorney and client, you'll always be able to charge for waiting time when you're crowded out. The aforegoing must be distinguished from waiting time before the matter is called on that day. In other words, you are set down for 9 o'clock, but you call it 12 o'clock. That you can charge for waiting time because then you were in attendance. So there's a distinction between when you are not heard at all that day or when you heard later that day. In the latter matter, you can charge for waiting time. Next, we come to perusal. The act of perusing or considering a document or a letter should be held to mean the application of a trained legal mind to the contents of the documents. The act of perusing or considering a document or letter should be held to mean the application of a trained legal mind to the contents of the document in question. That's a matter of Thornycroft cartage. Now, you sometimes have a case where a person has to read a book of so many pages. The taxi master has discretion to allow you a reasonable time for that or a lesser amount for perusal. And the taxi master will not very easily give you a time for reperusal. That is not readily granted. Next, cost of an interlocutory order in the match court for costs cannot be ceded. Cost of an interlocutory application in the match court cannot be ceded. That's section 49 of the Match Courts Act. Now, guys, just to show you how a bill of costs is drawn by way of experience, just give you one example. And before I do that, again, I say to you that a bill of costs is nothing more than the following. You've taken your well-kept file, you have demarcated correspondence and consultation time and pleadings and whatever else, and you marry that with a tariff. That is your bill of costs. But how careful you must be, I'll give you the following example. In item C1A of Rule 70 in the High Court, rather, item C1A of Rule 70 High Court uses the phrase, quote, important letter, notice, or document. And that has a tariff. Whereas item 1CB uses the phrase material document. So in the one case, we have an important document. One case, we have a material document. What is different? How do you debit the different amounts? An important document forms the basis of the course of action or defense. In other words, the bonds or the deed of sale, that upon which your causa is based. So an important document forms the basis of the cause of action or defense, bonds, deeds of sales, and so on. Whereas a material document only has evidentiary or probative value. A material document has evidentiary or probative value. So guys, it shows you how you have through experience, and that's the only way you get to learn to do a bill of costs. Try, and try again. Rule 33.4 of the High Court, where you can separate the merits and the quantum. At the end of a trial, let's say you have a damages claim. For example, I once had a case where a person was a guest in a block of flats, and the question was what caused the death by, or the injury by way of death, by way of gas rather, and whether the quantum was satisfied. So you first have to then adjudicate the liability before you can adjudicate the quantum. Can you separate them? Yes, you can. And when you do that, the court can then, at the end of the merit section, award costs, which you can then tax and execute upon, and then leave the adjudication of the quantum for a later date. Next portion, a lay litigant may recover out-of-pocket expenses, but not any fees. A lay litigant may recover out-of-pocket expenses, but not fees. That's nationwide detectives. We come now to counsel's fees. Counsel's fees, I want to refer you first of all to the case of Solomon versus McManus. Solomon versus McManus versus Janki Prasad. This was a judgment by Judge Mayer 2 September last year, where it was held, going back many decades to Per and Ibbison, but the trade usage Mayer J held here was the trade usage that the attorney is liable for counsel fees has been hardened into a rule of law. So guys, first of all, the first point about counsel fees, the attorney is liable for counsel's fees, not in the first instance the client. So the trade usage that the attorney acting for the client, the attorney is liable for counsel's fees, and that's now a rule of law. So it's now beyond any argument. And just by the way, in this case of Solomon and McManus, the attorney was held liable for 4.1 million rand. So make very sure that when you incur costs like this, that you have your deposit in your trust account, nowhere else. Counsel's fees. Counsel's fees are covered basically by our Code of Conduct, paragraphs 29 to 35. And I'm here to give you a brief summary of these paragraphs, 29 to 35, with some preliminary remarks. Paragraph 26.5 of the Code provides that counsel may decline the offer of a brief if agreement between counsel and attorney is not reached. Guys, I want to stress this. The fees should be agreed when presenting the brief. The attorney should know, and the advocate should know, what amount are we talking about. Yes, sometimes they have to be staggered, as I spoke about yesterday, but there should be no argument about what amount is payable and when it is payable. We so often at the LPC get arguments that there was no agreement in RAF cases. RAF cases take years and years. The advocate wants fees after 97 days and the attorney doesn't have the money. Guys, it's incumbent upon both of you, attorney and advocate, to arrange beforehand. You know exactly what's going to be paid and when, and you know now by whom, by the attorney. Paragraph 29.1 is that counsel shall remember that their vocation is or that their advocacy is primarily vocational and exists to serve the public. Counsel must calculate a reasonable fee, having regard to various factors: time and labor required, customary charges, the novelty of the work, the skill, the amount, stability, seniority, and so on. Paragraph 27.4 of the Code, counsel may only receive money from the attorney. He may not receive money from a client. That, of course, excludes a trust advocate who may and will receive money from the client directly. Counsel can accept or refuse a brief that's given to him or her that's already marked with a fee. It's the counsel's prerogative to accept or reject that. In terms of paragraph 30.2, counsel must, when receiving a brief, accepting same, stipulate what his charges will be, the daily or hourly rate. What's going on now? Paragraph 34.2 of the Code provides that counsel shall render accounts to the instructing attorney or arbitration body and shall receive payment only from the attorney or the arbitration body, as I said before. A brief to settle an agreement or to resolve litigation shall not be recorded as a brief on trial. This is really important. That's from that Geach matter. A brief to settle an agreement or resolve litigation shall not be recorded as a trial on brief, or sorry, a brief on trial. And a brief to negotiate a settlement shall not be recorded as a brief on trial. And in paragraph 35 says that counsel may sue an attorney for his or her fees. Now, guys, there's very few guidelines or rules about counsel's fees. There are a few in the Magistrate Court, but at the moment there are no guidelines from the point from the LPC. They will probably come in due course when our fees are determined by the LPC with guidelines. At the moment, there are very few guidelines in regard to counselling, besides the COC paragraphs I read to you a few moments ago. It's been important in the Match Court, part 4 of Table A of the Match Court contains various references to counsel's fees. In other courts, counsel fees are not regulated. Junior counsel's fees should no longer be a percentage of the senior counsel's fees, but a normal charge for the work done by the junior. That's also part of the SA Law Commission's recommendations. Consultations with client to prepare for settlement negotiations, subsequently reported or allowed on party and party. Consultations with client to prepare for settlement negotiations are party and party. That's Kruger and Mostert, page 68. Counsel's fees for party and party, counsel fees for preparing expert notices are not allowed between a party and party. Counsel is not entitled to a joint fee unless the matter is involved, and then it should only be allowed as per the tariff of an attorney. So counsel is not entitled to a joint fee unless the matter is involved, and then it should only be allowed as per the tariff of attorney and client. That's Crick versus Bayer, B-A-Y-E-R, and Mostert and Kruger and Mostert, page 97. And then for the attorneys, a standard agreement, a master copy used on a multiplicity of occasions. A fee may be charged for each time it is used. A standard master agreement used on a multiplicity of occasions. fee may be charged for every time it is used. That's Council Meeting Item 98, 19 May 1971. A taxi master shall only allow the cheapest reasonable travel costs by road or by air. A taxi master shall only allow the cheapest reasonable travelling costs. Case of R.H. Christie and Taxi Master. And then the final item from my side before we start answering your questions is that the following scenario. You have a matter traversing many, many months or years. You have given your client a number of interim accounts, which he or she has paid without protest. And now comes the last final account, but you lost the case. And now the client's enthusiasm to pay you has waned. And he or she now says to you, I won't pay you. I want all the accounts taxed before I pay you the final account. Can he or she do so? No, he cannot. She cannot. And the authority, two cases, is Praxley, P-R-A-X-L-E-Y, Praxley Corporate and Worksmans, and Fluxmans Incorporated and Dynamic Shell. They both be in your authorities. Where it was held that where the client has paid interim accounts without protest, he or she cannot now make the payment of the last account subject to taxation. Now, the caveat I have in that case is R.H. Christie's case. It's an SCA case of October last year, where it was held that where there was a unsophisticated client, the court would not hold this against them and would allow that client to then request taxation, but any other case would not allow it. Right, guys, we'll break for 3 or 4 minutes. We'll get all your questions, and then we'll answer the questions, whatever we have. But you're more than welcome. Let us have your questions, please. While we're waiting, let me just answer a few that we had from last night. If the court order reads as follows, when can a bill be taxed or payable? The respondent is ordered to pay costs of the application, which costs shall include the cost of the appearance, which are taxable and payable thereafter. Now, in the High Court, no doubt they're taxable immediately and executable. In the Match Court, the wording is a bit strange, but I would suggest that that will also allow you to tax and execute immediately. The next question was, I work for the Compensation Commission. In the Legal Services Division, the tribunal granted an order in favour of the Commission, including costs. No counsel was appointed in terms of the Competition Act. The tribunal order has the same status as the High Court order. Because no counsel was appointed and work done internally, doesn't mean we cannot charge any fees. Well, I'm not an expert on the competition field, but I have the following thoughts. In terms of Section 57(2) of the Competition Act, the tribunal may award costs against the respondent. Now, costs are not defined in Section 1 of the Competition Act. If you did not brief a legal practitioner, I do not believe that you can present a bill of costs for taxation, because the tariffs we refer to are costs for legal practitioners. So I'm not aware of any other basis that you'll be able to base a bill of costs on. So my provisional opinion is no, you'll be not be entitled to any fees there. The other standover question was that Rule 43, and I said to you that I thought that the rule had been repealed. The previous rule was that there was very limited costs allowed on Rule 43 applications in divorce matters. Now, sub-rules 43, 7, and 8, which provided for the limitation, they were repealed by Government Notice 1055, of 29 September 2017, effective from 1 November 2017. So now you have the normal fees, they're no longer constrained or limited. You have the normal charges for your normal work that you've done. So the Rule 43 limitations have fallen away as from 1 November 2017, Government Notice 1055. Then the other question from yesterday was, what happens if attorneys' fees and advocates' fees are higher than capital amount in contingency fee agreement? Do you take your fees or 25% of the capital? Well, if you recall correctly, what I said to you was that the attorney and advocate who signed the CF agreement are together limited to double their normal fees or 25% of the capital, which was the lesser. If the advocate did not sign that, then the attorney is limited and the advocate's fee is then a disbursement. Right, other questions we have? Could you kindly make clarity on the issue of how to calculate attendance fee on instance where the bill cost fee is less than 10,000 Rand? Right, let's say it was 9,000 Rand. Then you will have your attendance fee will then be 11% on 9,000 Rand, and that's the end of the calculation. If it was 11,000 Rand, it'll be 11% on the first 10,000 Rand, and then on the 1,000 Rand above the 10,000, it'll be 6%. Next question. If a cost consultant drafted the BOC, and if there was 20% of the bill taxed, how does a cost consultant get their drawing fee? Well, Beverly, if the tax consultant drafted such a weak bill that you lost 20%, I think he or she should get nothing. Really. How many years of experience would you qualify a cost consultant that is not an ordinary attorney to be an expert? Susan, there's no time period. It's a question of your experience. How quickly do you obtain experience? And you should use such a consultant who doesn't draft a bill that you lose your 20%. So there's no time period. It's a question of your knowledge. Some people get experience quicker than others, but there's no time period. Alzana asks the following. We have experienced challenges with taxi masters in some magistrates' courts that refuse to set down bills of costs for taxation. One of the following reasons. The account was taxed before. Well, that's quite absolutely say, well, you can't have a tax twice. So the taxi must be quite right in not taxing a second time. Question B, judgment was awarded with an amount for costs such as with default judgment, as well as an order for further costs and party scale in execution of judgment. Practically, we experience issues with this in the event that the tax account or judgment necessitates further action or enforce same. The taxi master then refuses to tax the bill of costs for the execution of the taxed amount. Yes, I think that he or she has justification that if the court had granted costs for, let's say, for default judgment or whatever else, you are limited for that, because the court might sometimes say judgment for so much and default judgment costs of so much. You are bound by that. You can't go beyond the court order. So the taxi master and you are bound by the wording and the parameters and the extent of the court order. So he or she would be quite within his or her rights. You carry on. Logically, if a judgment or tax account is not satisfied by the defendant, further costs will naturally arise. Should we then issue a summons for these costs? How do we approach these scenarios? Yes, you are bound by the amount of the judgment, but as you do further work, you'll be entitled to a further costs. That would then be, for example, the writ of attachment. The writ of attachment has its own fee, which the registrar would normally allow, and then it will be a reissue. If you have other applications, you're entitled to those costs, but you are bound by the first order, and then you're entitled to further costs as the matter continues. The High Court tariff is on page 137 of the manual. Yeah, guys, but bear in mind, thanks, Nina, but I think that is now outdated because there have been subsequent increases in the amendment. So which of the council fees are actually allowed where it is party and party scale? In the High Court, there'll be many items allowed: consultations, advice given, attendances, attending trial, many of them will be allowed, except where I said that they're not allowed. So they're normally they're allowed in high court tariffs. Match court, they're limited to what the match court says. Advocate Mohammed, if you have an experienced legal secretary who urgently consults after hours and drafts a founding affidavit in an urgent application, which due to time constraints you could not attend to, how would you allocate her 10 hours work on a bill of costs? You as a legal practitioner would have taken 10 hours to consult and draft. Right, this is difficult. A legal person didn't draw it, neither an advocate or an attorney. So you don't have an admitted attorney or advocate drawing the documentation. I think that you'd be bound and limited to your perusal of it, your settling of it, your working through it and approving of it. I don't think that you'd be entitled on a bill of cost basis to debit the fees of your your experienced legal secretary. I know they're sometimes very good. They're very good. I know one could do it quite easily, but you can't charge for that. WC, if an attorney's mandate has been terminated, can the new attorney start preparing his or her bill of cost from the period of the initial instructions? No. Let's say attorney A takes the matter from day 1 to day 20, and attorney B from day 21 onwards. Each attorney must debit and draft his or her bill of cost for the work done whilst he or she had the mandate. The second attorney cannot draw a bill going back, encroaching upon the first attorney's time of the mandate. No, it must be, each one must do their own. Beverly, are there any tariffs we can use when it comes to junior and senior counsel invoices? No, there are no tariffs whatsoever at the moment. There might be in future, but none at the moment. They are normally what is normal. Every bar has a basic usage that you get to know about, but there's no tariff as such. Emma, does this apply to in-house counsel as well? In-house counsel are not practicing, so they would not be bound by the tariffs that we have before us been talking about. Vulani, is it ethical to grant a client a discount for work secured through a bidding process, tendering? Yes, but you hear my reservation. I say yes. There's nothing wrong with granting a discount for bulk work or through tendering. I'm always apprehensive with certain commercial concerns where the attorney is almost expected to sell his or her soul to a corporate client. In other words, you pay me what I tell you, you'll charge me, otherwise you won't get the work. Okay, but to answer your question, it's not unethical. Julandi, please repeat the cases referred to about client insisting on taxation of final account but paid interim. Yes, that's the case of Fluxman's Incorporated, and Dynamic Shell. It's a 2015 case, Gauteng division. The other one is Praxley, P for Peter, Praxley, Praxley Incorporated. Sorry, Praxley Corporate Solutions and Worksmans. That's a judgment on 28 February 2017, Gauteng Local Division, Johannesburg. Susan, attorneys whose mandates were terminated after 12 to 36 months of work but do not render invoices regularly, have neither oral nor written signed fee agreement, but the work was done. Are those attorneys entitled to their fees for the work done and on what scale? Meaning, time basis or applicable court tariffs when client refuses to pay. Right, Susan, the answer I think is the following, that in the absence of a signed agreement, so therefore you have no fixed fee mandate or fee structure. In the absence thereof, you're entitled to a reasonable fee, Now, whether it is an attorney and client, you will take the party and party tariff and add on an amount in terms of the consider matter. You look at the complexity of the work, the duration, the importance of the work, the amount involved, and then you up the party tariff by a few percent, 10 or 15 or 20%. But look at the Coetzee and Celan case. That should answer your question. Trish, if the client agrees to an hourly fee, is it correct that every item charged will be a proportion of the time it took to carry out, for example, fees charged 2,000 Rand per hour, drafting email at 5 minutes? Yes, it's then 2,000 Rand per hour or pro rata for a portion thereof. So half will be 1,000 Rand, a quarter will be 500 Rand, and so on. Yes, that would be quite in order. Can you elaborate? This is now Beverly. Beverly, can you elaborate on the issue of VAT for disbursements on council's fees? Yes. The basic rule is that you do not charge VAT on disbursements because the disbursements normally have their own VAT. Now, let's say you get a council's fees for 11,500 Rand, which comprises 10,000 Rand in round figures and VAT of 15%. In other words, council's fees already then have VAT. If council is not registered for VAT and to give you an account for 10,000 Rand, then you can't raise 10,000 Rand VAT on that. You can't do that. So council's fees, if they contain VAT, it will be in his or her invoice. You don't add VAT to any fees that don't have VAT. Shelley, hi, with regard to what I asked yesterday about being in court to oppose a bill in front of the taxi master, it is a practical question. If I'm representing the plaintiff presenting the bill and there are two separate defendants opposing the bill, how does that take place in the courtroom? Does the first defendant give me their objection and then I respond to it? Well, Shelley, no. They should have given you their objections beforehand. The whole idea of the objections is that they must identify the objections beforehand so that you can prepare for that. So you're not taken by surprise the day you are before the taxi master. They give you, in terms of the rules, they have to give you the precise reasons for the objections, whether it is attorney and client or whatever they want to raise. They give that to you in writing beforehand so that you can prepare. The first and second defendants must each give you their objections. You prepare for that, and then when you get to the taxi master, you present your case, taking into account their objections, and they can then rebut it. I hope that answers your question. They say you have not faced two defendants opposing the bill before. Don't be intimidated, even if there are 10. If you are satisfied, if you are prepared, and I want to say if you are prepared, preparation is the golden word. If you have looked at their objections, you've done your research work, don't ever fear. And good luck. Right, Joel, if you are awarded costs in a different forum, i.e. the company's tribunal, but the adjudicator does not stipulate the scale of taxation, in the process, how do you suggest one possibility as an aside, should we make it a total request to adjudicators to stipulate in future? Yes, please do that. The company's tribunal should normally be equated to a high court tariff. So I'll suggest that you use that in the absence of anything else. Susan, cost consultants with more than 30 years experience, but not an attorney, are they still regarded as unqualified by laypersons? Well, I'm not quite sure about layperson, but certainly by the law, yes. 10 years, 20 years, 30 years, 40 years, they are still not entitled to be an attorney. Their years of experience as a cost consultant doesn't promote them to be an attorney. So yes, they are still not qualified to appear as I wrote to you before. Petunia, please advise in terms of a claim not in sound money. Where costs are granted, please advise as to how draw the bill of costs. It will be difficult to establish the amount which clarifies the scale applicable. So I think what you're talking about there is, let's say you applied for the eviction of somebody. How do you then determine the scale? As far as I know, you do it. You base the value of the occupation. I know it's difficult, but you have the value of occupation, and then try and persuade the taxi master to do as high as possible. Radishidi, can we please have copies of the answers to the legal cost exercises? We did the à la couture. That will be given to you, yes. my dear colleague, Merle September, will give you those replies. Emma, if High Court tax masters are indisposed, can a tax master from Labour Court review or tax the bill of costs? Well, only if he or she is appointed or is a taxing master of the relevant court. Sometimes you have people being seconded backwards and forwards between High Court and Labour Court. So as long as they're a registrar of that court where the bill is being taxed. National, for clarity, council is not entitled to drafting fees in an application at a High Court party scale. No. If he does, he must then do it on the same scale as the attorney. Kagisu, kindly explain how to calculate the less taxed off by the taxing master. Well, less taxed off is simply that the taxing master has looked at your bill of costs and has determined that either the work was not done, or that you used the incorrect tariff, or that you included in a party bill item that should be attorney and client bill. That's how he or she taxes off your items. For example, the court, you might have traveling expenses by flying from A to B, and the taxing master might say, oh, but you could have used a correspondent, or you could have used a car, would have been cheaper. That's how they tax off things. And also from Chancellor, and taxing master will tax off a bill where heads drafted by council are added on the party. Yes, if the taxing master believes that it's unnecessary, but it'll look at the necessity and then tax off or not tax off, yes. Tibogu, may we please get the answers to the question exercises included in the guide? And the list of authorities that will be provided to you. Do we have a template on a notice of intention to oppose a bill? I believe it is in your main bundle somewhere. It is there, yes. Susan, read the allocateur. When a calculated amount comes to, for example, an allocateur, example 3, calculation of 3% attendance fee. Don't the 92 cents become 93 cents? Guys, there's always a change of 1 or 2 cents because you get portions of cents, fractions. Yes, you can always get a difference one here or there. That's quite acceptable. Everybody, I have previously added my council's fees in the bill of costs. Of recent, I have noticed that my council's fee should not have input of tax. As per the other side, some taxi masters overlook the VAT issue. Please can I have some knowledge read the VAT issue for these costs on the disbursement. Well, I think I've tried to explain that one must look at fees and disbursements totally differently. The fees are your fees. If you are VAT registered, your fees get VAT added on them. Your disbursements, you very seldom, almost never add VAT to your disbursements. If council is not VAT registered, then he or she will give you an account, and that's the end of the account. If he or she is VAT registered, his account will include VAT, and that's the end of that matter. So the basic rule is your fees get VAT, the council fees do not get VAT. So that should answer the question. Hopefully Beverly, that you're happy with that. Mimi, please advise why bill of costs in liquidation and secretation must be taxed in order for it to form part of administration costs. Would not in any case be administration costs? Yes, Mimi, they would be, but in what amount? So the creditors and the liquidator trustees require the bills of cost to be quantified so that they know, because if you give them an account for 10,000 Rand, how do they know that it is correct? Why shouldn't it be 9,000 Rand? So that's why they should be liquidated, i.e. taxed, to prevent any argument by creditors or by collusion between the attorney and the trustees that the account's too high. So yes, they're always taxed, and then there's no argument about the quantum of the accounts. Guys, we'll give you 2 minutes for any further final questions. We'll break for 2 minutes to wait for any further questions. Beverly, what happens when there was a notice of intention to oppose the bill? Now the time frame has elapsed. What's the next step? Well, if they gave the intention to oppose and did not give their reasons, you set it down and you argue it without them being able to raise any objections. If they gave you their objections, you can set it down for a taxation and argue your case. Guys, those are all the questions I have. Final call before we end the presentation. Any final quick questions? Is a correspondent allowed to charge for perusal of documents sent to them for filing, etc.? Does this not constitute a duplicate? Yes, guys. That's Tricia. That's exactly the point. That a correspondent should not be charged on an attorney and client certainly, but on a party and party certainly not. No, that's duplication. Guys, thank you for all the thank yous. I've enjoyed it. I hope that it empowered you. You enjoyed it, and go well and enjoy the legal practice. Thank you and goodbye.